Today's question is being a divorce lawyer miserable? Miserable? Well, can be and is for some divorce attorneys, but for me, it's chronically discouraging. Sure, the human pain and betrayal to which we are exposed as divorce attorneys is saddening, as is the toll divorce takes on innocent children. It's saddening to see a nuclear family ripped apart and to witness the different but inevitable and short and long-term consequences for every member. It's annoying to see who should be mature adults wasting their precious time, resources, and emotional reserves on anger, conflict, and one-upsmanship. What makes it discouraging for me particularly, however, is the way most courts still treat fathers generally. That is to say, as second-class parents and sources of financial support, but not as important to a child as a mother, not as crucial an emotional and psychological component of a minor child's upbringing. While it is true that fathers are gradually being treated more fairly, it's still discouraging how often courts presumptively write off the father as unequal to the mother, how they presume fathers don't love and care for their children as much as the mothers, how often the courts will, in some cases, analyze what the physical custody and parent time award will be by asking essentially, what's the minimum the kids really need with their father? I'm frankly amazed how seldom courts in my jurisdiction refuse to give joint physical custody so much as a losing chance when the courts can easily test it during the pendency of the case before making a final determination. Instead, some courts retain the services of custody evaluators to predict what's best for the kids without actually testing the hypothesis. Why? There is no good reason why. Let me give you an example. Imagine you want to buy a new car. Imagine it's going to be a major investment. You'll be driving it a lot each year and for many, many years. It needs to be the right fit for you and your family. The car you ultimately get won't be perfect, nothing is, but you want your choice to be as good a fit for you and your family as possible, like everyone else in your position. Now imagine you're told that of the cars you're considering, you are allowed to test drive only one of them. Indeed, while you're contemplating which car you'll ultimately buy, you will be restricted to test driving only one of the possible choices. There's no compelling reason why you can't test drive each of the 3 or 4 cars you might be considering. No reason why you shouldn't. In fact, there's every sensible reason why you should. But the dealerships simply dictate that until you make up your mind, you won't be allowed to test drive any car but one. And you can only do so for several months before you make your choice. When you ask the dealers why, if they give you any answer at all, it will be something along the lines of, well, these cars aren't lab rats. Actually, they are. Or test driving a car might harm the car, so it's not worth the risk. But then again, letting people drive the car to see if they like it might actually help sell the cars. Or test driving more than one car may confuse and upset you. May, but not very likely, and that's still not a good reason not to test drive cars. When you ask the dealers, how can I make the best choice of car if you deny me and my family the most useful and meaningful way to choose, i.e. test driving? The dealers will then tell you that either they will choose for you and that a car choice evaluator may be appointed to help the dealers, not you, decide what new car you will buy. It makes no sense, but the dealers will tell you, we've told you how our customers' cars are chosen, so the matter is settled. That's often how child custody has been determined for as long as I've practiced law. No matter how many times I have asked courts to test competing custody proposals, to compare, say, joint custody against sole custody or primary custody, so that the court and the family, and that includes the children, can experience the different schedules and learn what is best in a real-world, case-specific setting. I have never had such a request granted. Not once in 23 years of practice, nor have I ever heard of a court doing such a thing in any other child custody case where I practice. That makes me miserable.